One of the concerns, we don't like the clothing you're wearing, it's anti-OT. Just know that I've learnt that you don't have to go through a hearing process to win it. When you figure out that, like a lot of families, they think that because OT's in on it, OT's doing an investigation into them, I've got to do whatever they say because there's allegations come forward. But over time, what I've looked at is, yes, OT have the allegation come forward and talk to you about reports of concern, but they're not the ones who have made the reports of concern. So you've got a lot of families out there and whānau out there that are looking at it on the basis of, but OT said this, and they put this allegation forward. But when you sit back and you actually think about it, it's not OT that's done that. They've taken on the report of concern. We take them on challenging them on that report of concern, but the issue is it ain't them that made the report of concern. So what happens is the lawyers in there, they say to you, you answer back on the affidavit they've given. But if you do that, you're not actually addressing those concerns, because the concerns that they put forward are third-party concerns. They're not the actual concerns that came forward. They're not the report. And so, how I finally worked out that, okay, let's not deal with their concerns. Let's deal with, here's what you gave us as well your report. For instance, in Baby's case, there was 2 reports of concern. There are 2 things that were in the report of concern from the hospital: not following medical advice, which was followed, okay, and using the nasogastric tube in a way that wasn't safe. However, the second one, it said, we got a flow chart, and it said that if you blended it up enough, like commercially blended it, then it should be fine to go through the tube. As soon as we found that out, Jess went and bought a 1200 watt blender, which was on the actual flow chart. So naturally thinking that, okay, if you're doing that, you're going by what they state is the correct way to do it. But then what they said to us was, it's got to be on a, what was it, a 14 French tube, which is the diameter of the tube. Okay, so the internal diameter of the tube has to be a big one. But what I said to them was, okay, but what you're not taking into account is when the homemade shake was made, I got her to run it through the pump, to test the flow rate and the viscosity of it. Okay, so if you take a milk powder that they gave and mix it up, and you run it for 10 minutes, how much goes through the tube? All right. Take the one we've made, does the same amount over 10 minutes go through the tube? It was exactly the same. So therefore the flow and viscosity rates were exactly the same as the milk powder one. So going by that, when you mix up the milk powder, not all of it actually mixes in. Whereas the way we were doing it, we were literally straining it and everything through the proper, and sieving it through everything to make sure every particle that couldn't get through a fine sieve didn't go through that machine. You can't do that with the milk powders that they do. So literally you could do it, but do they say that to you? No, they just say mix up the milk powder and put it in the machine. So if you go to Starship Hospital, they allow them to do that up there. They allow the parents to do it. But you see, we went from those 2 reports of concern to a year later, 16 of them. This is how stupid they were. The first social worker that uplifted Baby, okay, she couldn't be cross-examined due to psychological trauma from our case. Work that one out. Okay, so Black excused her on medical certificate, and then get this, locked the medical certificate so no other party could get it out. You know how they make it so no disclosure? So he actually locked it off and said that no other party could draw on it, could see it. the question then became in my mind, if she was psychologically traumatized by our case, what the fuck did you do to our grandchild then? She reckons she had threats through Facebook when we posted about the uplift. Apparently people found her private account and threatened to go around and do stuff to her. So, well, you know, that's nothing to do with us. But at the end of the day, they ended up putting the next social worker on, and her supervisor, we went to a whānau hui, it was set up down at one of their places. We went to it, and what I asked them for was, I want a list of your concerns that you have as at today. So we received this email that had a page and a half of concerns on it. So we went from 2 concerns to 16. One of the concerns, we don't like the clothing you're wearing, it's anti-OT. That they didn't like the way that we were putting it up on Facebook. Now, note that these are 2 concerns that have nothing to do with the child. Here's the kicker of it. That was on the 9th of March last year. There was a contact hearing on, I think it was the 26th of March. At the when the social worker's affidavit went in, we couldn't believe it. Over half of the concerns were gone off it. So when Jess cross-examined her, she asked her straight out, you guys sent us an email with a page and a half of concerns, and this dwindled down to less than half of that. Is there any reason for that? Social worker's answer, yeah, there is. I didn't agree with what my supervisor said. What you've got to look at in our case is the second social worker has had 15 years on the job and is still supervised today. I mean, what it really comes down to is what I've determined over time, and this is just my own thoughts on it. When any whānau out there is trying to find out what is the concern, you don't listen to what OT say is the concern. You ask, okay, what was the concern that was put forward for you to investigate? Because what OT's concerns are different to what that reporter concern is. They're always different. What the first question I would like, I mean, I've had a few, since Jess put up her post and I've put some things up, you know, people have been contacting me, and my first question to anyone who always contacts me is, what is the reporter concern? They go, OT said no. What is the original reporter concern? I don't want to hear what OT said. What I want to know, what to be able to work forward, what was the concern put forward, and who or where did it come from? OT, no, it didn't, because someone dialed into them to be able to make it, or emailed them to make it. And they go, I don't understand the difference. I say, well, the difference is what OT is putting forward is not necessarily what you need to mitigate. It's what the person rang in about, or the organisation, like hospitals. They'll turn around and they'll bring up, you know, like they did with Bubba. You know, oh, this is happening, this is happening, this is happening. Okay. That's not the way that OT put it across. That's what people have got to come to understand. What they say is there's a reporter concern, and then they're followed by these words, and we are concerned about. I'm not interested in what you're concerned about. I'm interested in what the individual rang in about. Email them and turn around and say, I'd like to know where the original reporter concern came from, not what you're worried about from that reporter concern, but where the reporter concern. I know you're not going to tell me where the reporter concern came from, but I want to know the original reporter concern. The interesting question that you want to ask them when it comes in is, and this normally I asked this at another one, is the person who made the reporter concern willing to get on the stand and give evidence? And they're like, well, have the evidence for us. And I go, no, you don't, because you're not the complainant. So are they willing to give evidence? And they go, yes. Okay, because if you're not willing to summons them, I'll subpoena them. And you normally find that if it's someone that's rung in anonymously, you're going to find your allegation disappears, because what people have got to be aware of is if they rung in anonymously, right, they're not going to have them to put on the stand. They're relying on Section 71 because no evidence required. But the issue is that even though there's Section 71 where no evidence is required, the upside you have is you can go, well, the Evidence Act 2007 section 17, 19 and 21 say that unless I can cross-examine that person, that is hearsay. But what happens is, under the Family Court Act, section 12A, Family Court Act 1980, section 12A, what it says is a family court can use that evidence still and rely on it, even if it's hearsay, but it depends on how much weight they lean on it. So what you normally end up having to do there is let the hearing go through. Judges are just not going to go in your favour. It's really that simple. And then start your process in the High Court. Oh, well, and Jess is here now, so I'll just turn the camera around a bit. There we go.
Yeah, for sure, without doubt.
The turning point, being really honest, is you remember how we spoke and then I was starting to change the way I did the paperwork and put the case laws in it in? Okay, so all of a sudden, when I started doing it that different way that we both do it now, all of a sudden the answers that came back in the statement of defence was, they were literally digging their way out because there was no way out. So what I put it down to these now, after going through all of that, is you've got to make sure you've got the case laws to back up what you're saying, but what you're saying also has to have the backing of the legislation. So when you put the case law in, it's one thing to use the case law, like for instance, I believe that the Nikau versus Nikau case applies to every single family court case out there. And Nikau versus Nikau was two families, a mother and a father, and the father's sister had whangaed the child for 4 years. But the basis of Nikau versus Nikau is that the whānaus were arguing. The father's side was, basically trying to threaten the mother all the time. And she wanted to move out of town. So what ended up happening was the judge decided that it was better, because you got two problematic relationships with the child, the biological side, like on the mum's side, for instance, it was the mum was living with her parents and dad. So the judge saw it as being better to prioritise that relationship because the siblings were also living with mum and dad. That's where Nikau versus Nikau comes into a lot of cases, because it comes down to like parents that are wanting to have contact. Okay, if there's two problematic situations, which one is the one to place the child with that doesn't have the problematic side when they're not around one another, like the two different parties? It's based on strengthening and preserving 5E and 5F of the OT Act and Section 5 of the Care of Children Act. So you've got to strengthen and preserve the relationship. And all of the lawyers out there don't do that. There's no way they're going to do that, because strengthening the relationship means ending the case earlier. Ending the case earlier means I can't fill my pockets up with cash from legal aid. That's my view of how the system works. I mean, at the end of the day, you've got so many lawyers out there that are cashing in on the system, and so many kids out there that are being traumatised because of what the lawyers are doing. The sad part about it is you get assigned these lawyers. These lawyers all have the ability to, I suppose the way I would put it is this: we use sections of the law that lawyers won't use. And why do I say lawyers won't use? Because when we were in the courtrooms and that, and we were bringing up these sections, you wouldn't expect the lawyers to be racing for the law books and the legislation to find out what the fuck are you talking about. I mean, like for instance, okay, I sat in on a meeting last week, and they were talking about all these different things, and I turned around and said, well, hold on a minute, because they were talking about like making a plan for a child, and they wanted to know about what the parents thought. Okay, and then the parents' lawyers were going back and forth with the OT lawyer. But the thing is, at the end of the day, I don't know why lawyers can't just come out and say it straight. They were going back and forth going, well, you know, this should happen, this should happen. So I unmuted my mic. And I turned around and said, just for clarity from the OT lawyer, you're expecting mum and dad to give you what they think of this report, right? They go along a year. So how are they going to give you what they think of the report when you've got to give them what you say needs to be done for them to have their child returned to them? And she went, yeah, it's impossible for them to answer your question on the basis of, I can answer it, but all I'm giving you is more ammo so you won't give my child back. And I said, the way this needs to be dealt with is you need to tell them what the objective is, what they need to do, and then they can go away and do the work if it needs to be done. And she said, what do you mean if it needs to be done? I've dealt with a lot of people, and I know that OT makes you do stuff that doesn't need to be done, and they're not here to jump through all your hoops. They're here to get their child back. And so I turned around and I said to them, now, are you guys doing a plan? They said they hadn't done a plan. And I said, well, my suggestion, I told the father's lawyer, my suggestion is that once they come up with this plan, it's subject to promissory estoppel, and it stops after the 6 months. And just the look on their faces were like, what are you talking about? I said, you're well aware of what I'm talking about. It's in common law. It's been doctrine for years. So just, if you're putting a plan in place, then do it. So yeah, that case has gone from, and this is the silly part about it, it's gone from return home to no return home. And so the father rang me and he goes, they've said no return home. I was like, oh, brilliant. And he goes, why do you find that a happy joint, a happy thing? And I said, because once it goes from a goal of return home to a goal of no return home, he goes, along this year, you now have the material change in circumstance to apply without notice to get your child back. It was a settlement through consented memorandum. That's an important thing for whānau out there to note, is that it doesn't always have to be by hearing. See, in our one, there's no evidence required because we pushed and pushed and pushed to the point where I ended up contacting the lawyer and saying, hey, let's have a discussion. We could probably sort this out through settlement by way of consented memorandum. He then emailed back saying, yeah, I can talk to you on Monday at 10 a.m. So I said, yep, no problem. So we did that. I think it was that, and I also think it was the fact that he himself was willing to acknowledge that it had gone on for a year too long.
Also the fact that we had it since the 30th of September, and then the 178 on the father did not help their case at all, so that drove it over the line. Yeah, that definitely drove it over the line. See, you know how you get people who turn around and say, I should get the 133 or 178 report critiqued. That doesn't have to be done professionally. We've critiqued hers, okay, I've critiqued 2 other ones and brought up points on them, and they've all been struck out. Because if you can find a CBT and DBT therapy, right? They will say you need CBT because of your, and DBT because of your interpersonal skills, right? And so the report writer will do that knowing, okay, I can do the therapy. No, you can't. There's only 3 people in New Zealand that can do that in DBT. One of them is fully qualified to assess, recommend, and do the therapy. The other 2 were trained by her to do the therapy. They are all in Auckland. So the psychologist that did her report stated that I believe she's got this. Well, how do you believe she's got something you're not qualified and have no scope of expertise in? The other thing that is forgotten there is the fact that when you go through these quizzes, when you're going for a psychological assessment, you go through these quizzes, numbers and everything. By the time you come at the end of it, doesn't matter whether you actually do have it or not. They're going to say either have CBT or DBT.
It's a rigged questionnaire. You cannot possibly have not one or the other.
Yeah, you have to have one.
You have to have one.
In their eyes.
It's funny you say the word rigged because it's exactly that. The thing is that when you get OT on your doorstep, this is the part that people won't know. The Oranga Tamariki Act is based off of the Carer Children Act. When they get a 78, okay, they'll apply for a Section 78, okay. What is the requirements for a 78? Number 1, it has to have gone through an FGC first, okay. If you haven't had an FGC, you can't get a without notice 78. what happens? The social workers in their 128 plan and their 186 report tell the court it occurred. So because they told the court it occurred, the court goes, right, tick that box, now we give the order to uplift. If you remember back to the Hastings Hospital case, there's the prime example. There was no FGC held. So it's I suppose the important things that people don't know, okay, if they come with a place of safety warrant, okay, a place of safety warrant, if you read about half to 2/3 of the way down the page where it has the different sections, okay, it says there that like a place of safety warrant is not an uplift order at all. It's a come into the house, check and see if the child's okay. If the child looks fine to you, turn around and walk back out. If you walk in and you can see, okay, say for instance the parent's smacking the child, right? Then I think it's halfway down, it's got B, and it says have reasonable belief that the child's in need of care and protection at the time I'm looking at the child. Okay, that's the part that turns it to an uplift order. Okay, I've got it in writing from Crown Law from when our one happened that a place of safety warrant is not an uplift order. It is simply an order to go and check on the child like a police safety thing. So it's a welfare check that turns into an uplift order if the child's in need of care and protection right there and then. There's two things that'll happen. The police will force their way in and take the child. Okay, so what you've got to be able to do once that happens is straight away you put a notice of intention to appear in due to the fact that the child, and this is the other part that never happened in baby's case either, within 5 days the social worker and OT have to bring the child before the court. That is under section 45. It quite clearly says that once they've got the child, they must bring the child before the court within 5 days to show that they've uplifted the child. Never happened because she was sitting in a hospital bed. All of these cases where they've got place of safety warrants, none of the parents are aware that that child's got to be brought to the court within 5 days, because after the 5 days the warrant's expired. If there's no order put in place by the court, the child goes back to mum and dad, and they won't, because of the fact that OT's put the child with someone else, but there's no court order. The section where the New Zealand police can turn around and uplift the child if they believe the child's in danger and pass the child over to OT. What people don't realise is, yes, the police have the ability to do that, but once they're placed with OT, there's no order. There's absolutely no order there at all. But the OT go, well, the police passed the child over to us. Yes, that is the case. That's understandable. It's in the legislation, but it does not give them the ability to hold the child. The notice of intention to appear is simply based on the fact that, like, if it's a section 39 place of safety warrant or a section 78, okay, the notice of intention to appear, if that's not filed, the next time it goes to the court, the order is automatically given to them. They'll get granted the 78 simply because it's the first 78 is only for a period of 14 days. So normally what they will do, sometimes what they will do is they will turn around and do a 78 1A, and the 78 1A means that your child is in care temporarily for 28 days. But OT don't tell you 78 1A. What they tell you is we've got a section 78. So you go and check out section 78 believing they've got interim custody. But if you get the if you ring the court and ask them what were they granted, and the court says to you they were granted a 78 1A, you know that from the time that they got granted, 28 days later your child comes back to your care. But people don't know that, so you get kids that are in care under a 78 1A for a year or 2 years on the basis that you don't know any better. I don't call it ignorance on the whānau's behalf, because you can't be ignorant of something you don't know exists, and that's where your counsel comes in. There's where the ignorance is. My feeling is this: where people go wrong, whānau's go wrong, is you, number one, okay, establish why they say they have the concerns. Number two, if they got those concerns, or the why are we worried, where did it come from? Okay, because if you're trying to mitigate the risk of OT, you will never win your case. Never. Because if you're mitigating the wrong circumstances. So, and
don't forget the evidence that they say that they hold in regards to it, otherwise it's unfounded allegations.
That's right. That's the first, when they say to you, these are the allegations, like I say, first question out of your mouth should be, and what is the substantive evidence you hold to support that? Because I know there is no way they could. Why? They're not the ones who've made the report of concern.
Therefore it's third party.
So therefore it's third party and it becomes hearsay. And so you've got to work your way backward. They're acting on hearsay, but what happens is it changes because of the fact that they, like, if I ring up and I complain about someone, they're going to turn my concern into what they're worried about. So when, like, if I say the kid's getting hit and they say, well, we have reason to believe the child has been abused, okay, so going from a child being hit to being abused, you've got many different categories. How do you work out which abuse category is? Was it psychological, emotional? Was it mental? You know, all those kind of things. Was it physical? So the normal, easy way to be able to do that is, my normal question to that is, so which part of Section 9 of the Family Violence Act are we talking about? Because you narrow it down. And so once you start to narrow it down, okay, so then you turn around and, like, if they say to you, well, there's psychological abuse, there's physical abuse. Okay, is that physical abuse subject to Section 59(2) of the Crimes Act 1961? So you're eliminating it bit by bit, because as you're eliminating it down, you're also eliminating their evidence. But in their mind, they don't see it from that point of view. But all the time what you're doing is you're just mitigating circumstances. The thing you've got to understand about in general, the court system, not just family court, is that if an expert is giving evidence, it doesn't matter how many witnesses you've got. If you've got witnesses from whānau and that and friends and that to be able to back you up, okay, kiss that evidence goodbye. So what you've got to be able to do is you've got to be able to turn around and find someone that, like, one of the ones you're dealing with, like if you're trying to mitigate circumstances and you've gone to an outside organisation, what people don't realise is that person that's helping you from that organisation is a professional. That professional has the ability to put in an affidavit, and that affidavit has the ability to knock out the other professional's evidence. Why? Because if a doctor says to you, for instance, okay, this is what's going wrong with the, with the child, okay, but then you've got someone who, like, for instance, the Child Development Service, right? So if you've got someone from Child Development working with your child, and you've got a pediatrician going, this is the problem, okay, if they've been referred to this Child Development Service, this doctor here doesn't have the scope of expertise to deal with this. So therefore, this doctor here overrules this one. So if this one here is saying that child's got global development delay, but this one here is saying, no, I don't believe that's the case, this one here is one that gets listened to, because that's the one that specialises in it. But what you've got to do is you've got to be able to work it around to getting them to come and give you an affidavit. Yeah. But I honestly believe that there's a lot more cases out there that could be done through settlement rather than hearings, because what I've found is going through the system is they don't want to listen to your evidence because you're not a professional. So the only other way, like, especially if you're a self-resettlement, do you have the ability to do it through a lawyer? I would say zero chance. Because what you're trying to be able to do is you're trying to mitigate circumstances that the lawyer, as an officer of the court, won't want to mitigate, because it means going against their peers. And so a lot of the time you don't have the opportunity to do that. But I strongly feel that doing all the research that I did and knowing the sections of law, that counteracted a lot of what they were doing, because it was stuff they don't use on a daily basis. They certainly weren't expecting me and Jess to file a habeas corpus in regards to a child being detained. But the actual act does have that. So anything that breaches liberty, and it's the effect of arbitrarily detaining it. Like everybody out there that has custody orders under care of children, right? Theoretically, going by habeas corpus, anybody who holds a guardianship order is detaining the child. That's the basis of habeas corpus. You cannot detain an individual. So even though they're a parent and the court's granted them, you can get granted custody, that's day-to-day care, but the minute they grant you guardianship, that's control of the child. So therefore the child is now detained. To me, I found it interesting because I was going through the different legislations. They were saying, the Court of Appeal agreed she was detained. They told us that straight to our face, she is detained. The guy that dealt with it for OT at the High Court that told the judge, no, she's not detained, we've got orders, 2 weeks later, told the Court of Appeal, I agree, she's detained. That was TWA. Yeah, it was TWA, and there was also another one, SL versus Chief Executive, because in TWA, what they stated was that the child had been detained, and then that was at paragraph 15, and then I think his name's Justice Goddard said to me, yes, but what we've got to decide was, is the child unlawfully detained? I said, well, not really, because at paragraph 16 it says the child's unlawfully detained. Those are the words. And then I turned around and referred to the SNL versus Chief Executive, and I said to them, it clearly states that at 26 that the Chief Executive said that if they had a guardianship order, that constitutes detainment of the child for the purposes of the Habeas Corpus Act. And then at 27, the Justice Katz, I think it was, turned around and said, so if the child was to come back from overseas because the child was overseas, and the Chief Executive applied for orders, that would be the basis, if they were granted, that was the basis for issuing the writ of habeas corpus to release the child. When you're doing the authorities, as you know now, like I do, you use your case law, but you've got to copy and paste the paragraph in that you're using, and then which is what they call citing it within your pleadings, and then footnote it down the bottom. So because if it's not referenced in the footnote, like I read this in the Supreme Court transcripts because I've been reading a lot of those, and one of the lawyers there, the justice told him, because the lawyer said, yes, but I've cited it, Your Honour. He goes, yes, you have. You've referenced it too. However, we didn't receive the judgment from him. On the other one, we received the judgment. You didn't cite it, and as you would be well aware from your studies, if you don't do those things, we don't acknowledge them. It's important because, like, there's, like, it was one of the other cases that I was helping with, and I couldn't believe it. They put in 165 references for authorities, and 150 of them were from the lady's own judgment from 2020. I suppose the easiest way to put it is this: you can go to family court, and the judge will make a decision. Then you'll take that to High Court on either a judicial review or an appeal. And it depends on what you're trying to do as to which one you would choose to do so with. Lawyers will tell you that either process can take up to 2 years. I can tell you myself, and so can Jess, that the first appeal we did was over and done within 60 days. The judicial review from the time we applied to the time the date of 12th of December, which is coming up, was given, was a 70-day period till the hearing. Why? Because we use the High Court rules to our advantage. Under the appeals, you have what they call a schedule, Schedule 6 and Schedule 7, and you've got to follow those schedules to do the timeframes. Normal timeframes is 25 days per party. I put my statement of claim in, 25 days for them to answer it. From there on, I've got 25 days to respond to the submission. Okay, well, by the time we bugger around with that all year long, okay, we end up somewhere between 6 months and 2 years, because the councils will keep adjourning it in the High Court. So what we did was, on the first one, was they turned around and said, okay, well, this is what needs to be filed. How long would it take me? So I said, I could have mine done in 10 working days. And so I thought, so yeah, not 25. So I thought I'd be smart about it and go, and that qualified, so they should be able to do it within 5. And we got those directions. When you look at it from that point of view, you've taken it from 50 days down to 15, right? So once you move past that spot and everything comes in, they'll then turn around and make sure all the paperworks have all been done. And in that time frame, we also got them doing the bundle, right? Which normally the bundle is another 25 to 30 days to do it. So you're up to 80 days, right? So in fact, we got all that reduced down to 15 days. Okay, they turned around and moaned that I had waited for a period of time. I said, well, it's not my fault you filed late. But however, I will compromise. There is 5 days left. I'll have 2.5 of them, and you'll have 2.5 of them. So the judge agreed, okay, I was being fair, and so directed that. They didn't like that because it meant that they had to hurry up. But the process takes a long time, because if the High Court lawyers don't do it in their way, okay, they don't make $4,000 to $7,000 per day in the High Court. Okay, so the way we did it, like, you're literally taking their whole process and reducing it down to 1/10. What sucked for them was when we filed the habeas corpus in the High Court, and they had to be ready in a day to go. That's what sucked for them. But it's, to me, what it is a lot of whānau out there will feel pressured to do what they're told to do, and if you're anything like us, it's basically get stuffed, we'll push back. Because at the end of the day, when you like, I mean, when Jess had her lawyer, you know, when you've got a lawyer that's oh yeah,
Oh yeah.
when you get your case files and you find that your lawyer was telling OT, yeah, I'll see if I can get the video from her so that I can give it to you, right? That's time for the lawyer. It's time for you to do something yourself. We started out like everyone else. You don't have a clue what you're doing, but if you're really wanting to pursue it, like I said on one of the posts I put up, you know, it wouldn't matter which one of my kids it was or which one of my grandkids it was, okay? If someone's going to come after them, then I'm going to do my best to stop them. I suppose the thing that I've learned over time is pass that knowledge on. Because if you don't pass that knowledge on, we're going to have another 6 decades of people still going to Royal Commissions in 60 years. I told the social worker when we first went into the office about Bubba's case, I was in their care from 14 to 16. So at that time, I turned and says, I can see that obviously nothing has changed in 34 years. And she goes, what do you mean by that? I said to her quite simply that you're still operating in the same way as you did back in 1985. I would say the things that you've got to look out for is, if you go to a whānau hui, like I've just been to with someone else, okay, whānau huis don't have a safety plan. Okay, they will try and implement a safety plan. The one I just went to, I turned around and said, no, there's no reason for a safety plan to be put in place. It's not covered by legislation under a whānau hui. It's not even covered by hui whānau. The only one that is covered by it is an FGC. Oh, but we must put a safety plan in place. No, you don't, because you don't even need to intervene. And the other thing I just came to know just lately is, like, I've always said to people, and I still believe this, okay, you go to an FTC and you agree to care and protection concerns to get a plan in place. You've just agreed to have your kid go into care at some stage.
The thing that Francis said.
Oh yes, the other thing that people need to know. Okay, when I had an understanding of it, but then I got a final understanding of it at the hui whānau that we had. Okay, the FTC coordinator for it brought up about the fact that under Section 28B of the Oranga Tamariki Act, okay, the whānau do not have to agree there's care and protection in regards to the child. They can just agree that changes need to occur for the best interest of the child.
So basically manipulation.
Yeah, so it's by going 28B, you remove the care and protection side of it. However, what I would say to that though is this: it may be in the legislation, but the wording of it, yes, it does say that. However, we know the people behind the bench interpret it in their own way. So I would still always say to people, don't agree to care and protection. Never agree to care and protection. It doesn't matter who's saying to you, just by agreeing to care and protection to get the safety plan in place. Okay, you want a safety plan in place, go to court. Get the court to order that safety plan happens, not then. Because at the end of the day, that we know for sure from our FGC, okay, we were told by Judge Black at the hearing, but you agreed to care and protection at the FGC. It may have been under duress, but you still agreed.
Now it was because my lawyer at the time.
Well, it was because her lawyer at the time, she ended up having a word to us, because back then we knew nothing, right? And she said, look, if you guys don't agree that she's in need of care and protection, they will take her today.
So it's the only reason we
That's the only reason we agreed. But what I have found, yeah, exactly. So that's one thing I can't reiterate enough with people is when you go to an FGC and you agree there's care and protection, even if you know there's care and protection concerns, you don't agree to it because it unlocks the key to the 101. So here's what happens when you go to the courtroom. You've agreed your child's in need of care and protection. So the minute you go to a hearing, that hearing's already decided before you start it, like ours was. And so
the way I see it is, if you're going to agree to care and protection, that your child's in need of care and protection, you might as well go, here you go, have my child, because that's what you're basically doing. So if you're going to, if they ever ask it, never ever agree. Just don't agree. They will always come back. You agree.
Yep.
That's it. End of.
The important things for them to realise, people out there to realise, is place of safety warrants, Section 78. Place of safety warrant, 5 days to do a notice of intention to appear. Section 78, you've got 14 days, sometimes 21. If you do a Section 139 interim agreement, okay, the interim agreement is not an interim agreement. Can't stress it enough. 139 leads to 140. Okay, so 140, that automatically from 139, they're automatically going to go to a 140 agreement. 140 is seen as being you agreed to have your child under a 101. So with the 140 in place, you just agreed to care and protection without knowing you agreed to care and protection. So the minute that they go, there's a clause in there where you can cancel that agreement within 7 days. However, you've got to be crafty about it, because within that 7 days, as soon as you go cancelling it, they apply to the court for 101, because 140 is 101. So those are the things, those are the orders you've got to be careful of, because even though they will sign an agreement with you, but the child will stay with you, okay, where's your ticking time bomb? When's it going to go to a 101? Because 139 can only be done twice. Once it's been done twice, it goes to 140. They don't have an option but to go to 140. But they get you to sign the paperwork saying it's the same agreement, but it's not, because 139 is a temporary agreement, okay, and the temporary agreements are supposed to go for 6 months, okay, and 140 is 1 year. Okay. The other thing that people don't know is under guardianship orders, a 110, okay, is an interim order, right? Sorry, 110 AA is an interim order. You can only have 2 of those over 2 lots of 6 months periods. Once those 2 6-month periods are gone, your child is now subject to a permanent guardianship order under them, automatically. And it's always going to drag on for more, because under 1342, an under 7-year-old, a plan has to be done for a 6-month period. Over a 7-year-old, it's for a year. Now, when they come up to review time, when those plans go in, it's a 186 report and a 128 plan that goes before the court. They have to be subject to Section 130, which means the court's decided the plan is adequate and appropriate.
That's the important part.
That's the important part, because without the 130 being done, you cannot do 101. Okay.
And without it being approved by the court.
And it must be approved by the court. Here's the catch: when Bubba was first uplifted, and they put the plan in, it never got approved. Illegal uplift. Well, you can't agree to something they never talked to you about.
Exactly.
And so what they did was they talked with the father's family and sorted it all out through there. The part that I found disgusting at the end was when, after we hit the hui whānau, the social worker came to the house, and she was just doing her normal 8-weekly check. But what she came out with, that was what disgusted me. I work with the family that's got the child. I don't work with the other family. That's how we're trained. So how does the other side of the family that doesn't have the child ever get contact, ever get any rights? because OT is training them not to have it. And so, do I believe we would have had a chance in court? Yes, on the judicial review, because of the way we had changed the paperwork. Do I believe we had better chance and easier chance through settlement? Yes. It was better to basically you use the judicial review or appeal process. This is what I have found, to then seek settlement with them, because they will want to do the settlement based on the fact, like when we changed the paperwork and we had the case laws and everything like that, and the judgments to put in and you're referencing, okay, that was when how they did their paperwork changed completely, right? Because originally we were putting our submissions in, they're just writing back normal submissions, right? Because what you got to understand about the submissions, and you understand this now, is that if you don't reference case law to say someone else won on this fact, right, then they don't care, they don't listen. You can go into a hearing like with having done your affidavits. Okay, here's what I'm going to say: affidavits don't mean shit. Okay, why? Because when they get you to write out an affidavit, you give your answer to what you say happened, right? No, you're giving your view or opinion or position on their allegation. What does that do? That nullifies your affidavit. You've just spent all your time writing it out and giving what the lawyers asked for, but the issue becomes you just nullified it. You just cancelled out your whole affidavit because it's going to have your opinion of what they've said on it. You can't have a view, an opinion, or a position on it. You can do that in submissions, you can do that in applications, but your affidavit can't contain any one of those things. Like they might turn around and say, well, I believe that their mental health needs looking at, right? Here's what I would write now. I cannot give an answer as that is their view. How they say critiquing reports, okay, you can critique any document. All you've got to be able to do is go, that contains a view, that contains an opinion, and that contains your position, right? So if you've got any one of those three within an affidavit, you've just cancelled your affidavit. But no parent knows that, so they're answering it, and that's what a case goes on forever. If they turn around and, like, for instance, they might turn around and say, I have seen a person, this person used drugs on this date, right? Okay, I would simply answer that by stating paragraph, say for instance paragraph 15. Paragraph 15 imparts their view on what they say they allege I have done. That way, it's not your view. You're pointing out it's their view. I spoke to a judicial officer barrister down south, and what he said to me was, when you do affidavits, I was like, yeah. He goes, I said to him, like, I told him what I've started doing is I'm referencing in, like how we do the case laws, I'm referencing in the evidence into the submission. And then on my affidavit, I'm just saying that, well, you just say you rely on what's contained within your submission, right? Because an affidavit can be struck out due to the fact that it contains opinion, like I say, opinion, view, or position, right? But if you're referencing the document, it's now an authority, so you don't need the affidavit. You still need to file an affidavit, but you're relying on the contents of your other paperwork. You also remove one other thing. You remove the opposition's ability to cross-examine you because you don't have an affidavit. You don't have evidence through affidavit. You've got authorities referenced in it, so therefore those authorities hold more power than the evidence. Here's the good part about it. The Evidence Act hearsay doesn't apply anymore because it's not in an affidavit. When you read, like, if anyone who's ever got a judgment, if you read through the judgment, you'll see where it's got the word, it's got the little footnote number. You go down the bottom, it gives the reference to it. You know that, right? But a lot of people out there don't. But that part there, in your document, when you're writing your own document, it removes the need for the affidavit. Sorry, the contents of the affidavit. Put the contents of what you're going to put in an affidavit and exhibit, reference them as footnotes, and cite them. So the part you're depending on or leaning heavily on, copy and paste that into your document and then reference it at the bottom. You've now got a referenced footnote that holds more weight than an affidavit. All family court cases, I'm going to go straight out and say this, all family court cases, okay, they at some stage will have either breach of natural justice. Okay, every single one of those is going to have breach of natural justice because, in my view, the judicial officers just can't control themselves. So they always do breach of natural justice. And the most powerful case law that I have found in regards to that is Maharaj number 2, which was from 1974, and is 1978. Is 44 years old, and as the Supreme Court put in a 2010 judgment, that is still the most powerful one in New Zealand for breach of natural justice. Okay, what I've worked out on the abusive process lately is like with the one I'm doing in the court at the moment. I've told the registrar straight out it's an abusive process because it contains falsities and stuff like that in it. Sort of caught them off guard because they went, we just registrars. So you know, so I was like, oh god, here I was thinking I was going to get over and done with that day. But they went, we just registrars. We don't have the ability to dismiss this. So, okay. But when it comes to those sorts of things, like the breach of natural justice, people wouldn't think of this as being a breach of natural justice. You know, you go to a court and you go to file documents and they go, no, I'm sorry, I'm not going to accept that for filing.
Oh, many times, yes.
Right. So as Jean Grey has proven many a times and also got it in a judgment, the judge, like how Judge Black stopped us filing memorandums. Okay, that is a breach of natural justice because you have to have access to justice, and one of those things is filing memorandums, filing paperwork. Okay, so if the court stops you filing paperwork, that's a breach of natural justice, and you have to be able to, like, even if it comes out in a minute that you can't file this or you can't file that, you go and appeal that because the High Court will tell them straight out, okay, you must accept it. You know, you cannot turn around and say to a person, you can't file. How can they access justice if they can't file?
Exactly. Even if you're kicked out of the courtroom, you still should be able to file.
Oh yeah. I mean, the weird thing was in our case, and we know. Okay, this is where their bias and non-impartial, and the being non-impartial comes in. How is it that we go to file a memorandum, the registry comes out and tells us because of this minute here, we can't let you file. 2 days later, the OT lawyer files a memorandum that goes to the judge.
Yeah, exactly. What's good for one party is good for the other.
Well, it should be, but it never is. But yeah, I mean, I would say to people, when it comes to trying to sort your case out and win your case, unless you know the things that we've learned through our journey, you're not going to have the capability, even with a legal aid lawyer, unless you've got one that's honest, touch wood, and the chances of that is very, very remote.
Can I freeze over?
No, because hell can freeze over and the lawyer's still not honest.
They'll just sit there and pull out a popsicle, as far as they're concerned.
Well, yeah. I mean, you've got to be able to. I would say, going on what other people have said in regards to certain things and how things work, then I should be qualified lawyer. Because going on the way the psychologist board told me that if they're qualified, they get their bachelor's or whatever in psychology, as long as they read the piece of paper that was put out by the person who's done the DBT or CBT, and they got an understanding of it, then that qualifies them to be able to do it.
Like
and I said, well, that can't be right. And she goes, why is that? Because on that basis, I'm a fully qualified lawyer at QC.
Yeah, exactly. If that's the rule they're going to use.
The main thing that I was going to really say for anyone out there is when you're going through this journey, all you really have to think about is what I had to make that decision when I did have a lawyer. Going through all this is, okay, you're going through it and where you're getting. You're not really getting anywhere, and I'll be surprised with legal aid if you will ever get anywhere. So for everyone to say that, you know, they love their kids and everything like that, but the real test is going to be, it's a damn hard journey, but you've got to sack them and go through it. As long as you've got the right support there and people that you trust there that will be there with you the whole way, like I have mum and dad and a few other people that are from, you know, professional side. So as long as you've got that good support network there, then yeah, you know, you get to have your moments where you have a bit of a cry or whatever, but you have to keep fighting the battle to be able to keep your little one home. Because if you don't, they're going to be stuck in the system. And if you know that is going wrong, especially for the best interest, health, safety, well-being, then as much as you can see that, okay, yes, they may be underneath those orders, if those orders are valid, or in our case, you know, they were no longer valid, but they'll say they are, do what is best for your child. If you have to keep them to know that they're safe, then do that, because at the end of the day, do you really want your kids to be another statistic?
Yeah, well, I think with your one, your orders had those orders were invalid from June onwards, weren't they? And they still tried to act like they were going for a few more months.
It's that and the fact that with my daughter, with her getting sick over where she was, and then coming back to me and needing the treatment she needed, then sending her over the medication she required, and then they're not giving it to her. Of course, if you're doing the right thing by your child, doesn't matter, you know, what, to me, that stage is like, well, okay, I don't care what the system says because the system is so corrupt. I've got to do what I need to do for her. And if that means saving her life, because there's a few cases going on when that was happening, and mum and dad even told me, look at this case. And it was a very similar situation to my daughter. And yet, those kids unfortunately passed away.
One of those examples is poor little Malachi.
Of course, that's going to get you as a parent. So you've got to do what you're going to do. If they're going to say, threatening you, oh, well, you know, you're withholding the child, you're breaching orders, will take you back to the court, let them do it. As long as you've got all the evidence to back up that you've been in the right, they did wrong, and you've got all the evidence from the doctors and everything to back yourself up, then do it, because at the end of the day, what do you have to lose? That's the thing, one of the things that Dad mainly said to me throughout this journey is, you know, when I was like, well, yeah, I want to do that, but I'm worried that, you know, they're going to stop her from coming back. And Dad said to me, well, at the end of the day, what you got to look at is, it's your decision, but is it worse her never coming back?
Right.
That could be the difference between, okay, you're going to keep her because she's alive and she's not. So is it really worth listening to what they're saying, or you do what you know is right?
Yeah, exactly. Yeah, it's more of the moral and ethical post that you've got to look at, isn't it? Even though some piece of paper says you can't do this, you can't do that, if you can see your child suffering because of the neglect or someone else is causing, you do what you have to do to defend your kid, irrespective.
Because at the end of the day, whoever that was, whether it be the other side of the whānau or someone else, at the end of the day, they will be able to, they'll go along and no doubt show the child, okay, this will be older, but then you'll be able to show, well, actually, this is the truth, and these are the ones who stuck by you and fought to get you back home safe. Because everything she's been through, she knows this is her safe home. And that's a sad thing for her to have to say that only this is her safe home. She should be able to say both sides of her whānau, she's safe.
You're exactly right. Yeah, both if they're both caring parents, then both places should be safe. Exactly. But unfortunately, they end up being fodder, don't they? You know, the kids a lot of the time end up being fodder between one parent to the other, usually as a tool to hurt one from the other. Or they're a money-making machine for a caregiver to make money from.
Yeah, and we're using your child to get what you want rather than what is best for your child. That's the second system.
The other thing that I think is a really major one in a lot of parents' cases is I always hear, but I want this, but I want this. And my answer to that is, show me where in either act it says in the adult's best interest.
Yeah. The acts aren't there for the adults, they're there for the child.
Yeah, and see, I think Jess is right. The other turning point was when they were OT were trying to make their threats about going back to the court and getting order to have her uplifted.
Scare tactics. Yep.
I turned around and we sat down and we wrote an email out, and I reminded them that under section 104 and 105, because that's what the judge had said, that we would risk her being uplifted under 104 and 105. But when you look at section 104 and 105, 104 is the effect of the custody order. So when people say my child's subject to a 101 order for day-to-day care, no, they're not. The 101 order, yes, that's there, but 104 gives the effect of the order, not 101.
Right.
So 104 says that a child that is subject to a 101 order is in the day-to-day care as if it were 48(2) of the Care of Children Act, because the OT Act is just based off of the Care of Children Act. Everything's the same, just different sections number. But the important part to know is, and what we wrote up, going by what my understanding of those 104 and 105 are, is that 104 is the effect of the custody order. They say that they'll get the police to come and uplift the child.
There comes the threat.
But it's subject to 105.2. 105.2 says that under 105.1b, 105.1b and c, because 105.1b and c is placement of the child, where the child's going to be placed. So an agreement has to be done as to where the child will be placed. The unfortunate part about it is that 105.1d is cancellation of the agreement. So they can place them back, your children back with you, and then under 105.1d cancel it at any time. The issue that they forgot about in this case, in our case, was for them to be able to implement 104 and 105, they first of all had to have the child placed under 105.1b or c. Neither occurred because there was no agreement to do so. So that removed the ability under 105.1d to involve police and remove the child.
Which goes back to exactly like Jess was saying, agree to nothing.
Yeah. So the what they didn't seem to understand from their own legislation, when a child is placed with a caregiver, the child is placed under section 362, not 105.1b or c, because those ones can be cancelled at any time under 105.1d. But the important thing for parents to understand is, if you've got worries about your child, like anyway, okay, and they say we'll go and apply to the court, let them. Where was the agreement for the child to stay with you in the first place? So under 105.1d, there isn't the, like, you've got to have 105.1b and c for the agreement. So if there was no agreement under those two, there's no ability to cancel under 105.1d.
Exactly, so they can go to the court as much as they like, but without the agreement, that's just an empty threat.
It's an empty threat on the basis of 105 section 105 subsection 2 doesn't apply as it's cancelled under 105.1d. And for 105.1d to apply, they had to implement 105.1b and 1b and c to place the child. So if you've got the child in your care, you can manage to keep the child in your care for 3 or 4 weeks, you're also establishing the fact that the care and protection concerns can't be what they're stating, because if they were, they would have implemented the 105 and the 104. But remembering there's the inability to, because they never made an agreement for you to have the child. So there's no agreement to cancel it.
Yeah, and the fact that they can't produce an agreement sort of takes the wind out of their sails for everything else.
Well, yeah, it completely knocked the wind out of their sails, because like she's just got an update on her IA files again.
Oh,
and from the records at that particular time, OT were the ones that stated, we don't want to, even though we've got a 101, we don't want to uplift her, traumatise her further, and damage the adult relationships further.
Right, and then so that's a key point, isn't it? Doing that OIA request and getting a copy of your file from OT, that's a big one.
Yeah, I mean, she normally does that every couple of months.
To me, I'd say not only OT, but any agency, any doctors, anything like that you have involved, always OIA them.
Yep.
OIA and Privacy Act request.
Yeah, I'm doing that with the National Intelligence Database at the moment for me.
And as she's found, always request not just your file, but any email communications.
Yeah.
Because they put the email communications separate on the system to your main file.
The full file, including the vault, V-A-U-L-T.
Yeah. See, people don't know that there's the vault in most of the government organisations, and what the vault is, that's where Darren Cassidy was right. He was the one who told me about the vault. And so we made inquiries to find out about it, and then all of a sudden, hello, you go from 6,000 pages to 9,000 because 3,000 are sitting in the vault.
Mm-hmm.
And so what happens is when they enter like OT, when they enter it into Cyrus, at the end of each day, Cyrus is uploaded to the government vault.
Right.
So, and the good part about getting the vault, you know how they turn around, they go and they change the case note?
Right.
You can get to see it from the start of when the case note was put in, and when they modified it, and where it's at today. So why have you got these three things when it was supposed to be the one?
Yeah, exactly.
And if you have the hospital involved when doing the request, do it through to the hospital, through the medical records, and also do it through to feedback, because medical records get you the medical records. The feedback part gets you all the communications to and from about your child.
Right.
So that's another important. A lot of information comes from there as well.
Yeah, but the so those are the main things I would say. Like for our case, like you say, it changed when I changed the paperwork, but I also feel that we managed to push them back into the corner rather than us being shoved straight back in the corner. It's the ability to know your rights and implement them. It's one thing to know them, but if you're not willing to implement them, you're never going to see change.
Yeah, you're exactly right. And it's how you put it on paper and implement them in a certain step-by-step fashion makes that difference.
Yeah, and I honestly believe if I hadn't approached them about the consent memorandum, this would have probably gone on for another 4 or 5 years.
Oh yeah, they would have kept making money out of you.
But it's using that process, like how they say once you file, you normally talk to the other party, right? So I decided, right, I'll give this a go, and I'll see if I can force them to do what is right by legislation. Then I realised what I'd actually done was, if you look up the family court when it was first implemented in 1974, the family court never used to involve lawyers until a hearing. And so what I decided was, okay, let's see if I can work it in that way to a settlement on the basis of we're mediating it, because the family court process, how they do FDRs, the family dispute resolution, that's supposed to be how the family court works. You're not supposed to have lawyers from the start.
Yeah, you bring the lawyers and you've got yourself an adversarial fucking fashion, whereas if it should be just between the two parties talking with mediation, that's the way it should be.
Yes, and so the way the family court system was originally set up is, you know how they have counsel to assist, right? That's what you have at the hearing. You don't have them before that. But they've gone away from that because we don't make any money that way.
Yeah, of course, they make more money sticking their nose in straight away, don't they?
Oh yeah, what it basically comes down to is, we as lawyers, we want to be involved from the very start. Otherwise, how do we screw you over?
Exactly. How can we mislead you properly if we don't get to start off with misleading you down the wrong way for a start? Honestly.
We've got to get into implicit to suit our narrative.
Yeah, because it's all about that narrative. But what you've got to be able to do is push that narrative back on them. So it's about mitigating the circumstances. Sometimes, though, what I've found in a couple of cases, and including in ours, you're trying to mitigate something that's not really needing to be mitigated because it never really occurred.
Never existed, yeah.
Exactly. So what you've got to be able to work out is, it took me a while to realise, okay, about the paperwork, getting the filings, and we got that done, and then we moved on. You've been through the journey with us, you know what we've done.
Oh yeah.
But it's I honestly believe if we had to go through it again, right, it would be over and done within 4 to 6 months max.
Yeah, knowing what you know now.
Because we know what we know now. See, first of all, when this first happened, I contacted Janet Mason, and she told me, this is what you want to do, in this order, tell your lawyer to do it. Her lawyer, I'm not doing that.
That won't work.
That won't work.
Yeah, and Janet Mason was the one that dealt with the Hastings case, wasn't she?
That's right. And the thing she told me to implement is exactly what she did in the Hastings case, and the order was gone at 3 a.m. in the morning.
Yeah.
You know, I honestly believe that you can go through the family court system, you can go through the High Court, you can go through the Court of Appeal. I can't say it yet about the Supreme Court, but in those 3 different forums, even when it's District Court, basically it's, okay, how much do you want me to kiss your ass so you'll keep my decision in place?
Yeah, and as you were saying, I think for the family court, it's a more of a broader thing. But then when you go to the High Court, then it narrows it down, and then Court of Appeal narrow it down even more and more, doesn't it?
So if you get a judgment from the family court, you've got to pick which paragraphs, or if you're doing the whole judgment. What I would say to people in that respect is, this is the two things I have learned. So under an appeal, if you didn't win on your evidence at the family court, judicial review it.
Yeah, no point appealing something you didn't win the first time.
No, it's because even if you try and put it across in a different way at the High Court, because the family court has gone no to their evidence, and especially on the basis if there was an agreement to care and protection to start with, okay, you've got no chance in an appeal. That's my belief now.
So it's only the judicial review where you might get it.
If you judicial review the decision, okay, you're not so much using, like, all the evidence still gets put in, but you've got the ability to use that process to get to a settlement without going to a hearing.
Right. Instead of
like what we did. You do have that ability. I mean, if the judge just completely ignored you on the fact of your evidence at the family court, and you know that you had everything right and you didn't agree to care and protection, by all means, go and do an appeal. It's possible that it will get overturned in the High Court, but I would say the possibility is about 1%, if that. I still believe you could use either the appeal or the judicial review process. As long as you got your paperwork right, use the process to get a settlement, not go to a hearing.
And the settlement's done by the consented memorandum, yeah.
The consent memorandum, and you see, you can go back and forth like we did and said, no, I'm not accepting this and I'm not accepting that, and they took it out. What
was the bad point you were pointing out to me a while ago now about consented memorandums? How the parents think something's been done in court, but
so, yeah, I've dealt with a case up in Palmerston North, and the parent was going to the hearing on the belief she was getting a hearing.
Right.
But what had actually happened was, in the 128 plan for the child, it was noted within the 128 plan that council would all work together and only go to the court once every 3 months if they required the order to be signed by the judge.
Right.
So she was going to court believing, why is the evidence not getting heard? Well, it was on the basis that all of the lawyers, including hers, had consented to the memorandum. So therefore, because a consent memorandum went in saying the child will go under such and such order, there's no need for the hearing time gets reduced down to 2 or 3 hours, because all the judges got to do is go, everybody agrees, yep, sweet, sign it, give the order.
Yeah, so it's more of a, instead of a consented memorandum, it's more of a conspired.
Yeah,
it's the lawyers conspiring towards them.
But you've got the ability on an appeal, because this woman's a lawyer. She said, I want to appeal it, and the lawyer went no. And I said to her, and I understand why she said no. And she goes, why? She said no. Why would you want to appeal something that you were part of?
Yeah, because you agreed to it.
You've got to mislead your client. And she goes, yeah. So on an appeal, that comes under irrationality and unreasonableness. She goes, long as they didn't follow your instructions. And she goes, long as and you're able to show that. So going by that, why would the lawyer show that she misled you?
Yeah, of course.
And then be
they don't want to show evidence of bad faith and get done under 272 of the Law Con Act, do they?
I just said that. But yeah, so a lot of it comes down to knowing your rights, implementing your rights, because like everyone else out there that I've spoken to, they go, I don't know if I can do it. Well, I can tell you straight now, I am nervous as hell every time I go to court. But if I don't open my mouth, how do I help my granddaughter?
Dead right. It's a matter of what matters more to you, your personal fears or the child you're trying to stick up for?
Oh, I get really bad anxiety when I go in there. But I look at it from the point of view...
couple of vodkas, no probs.
Yeah, I mean, but I just look at it from the point of view, and I say to every parent that I speak to, like some of them go, I can't self-represent. Yeah, I can't self-represent either. And that's being honest, because I'm scared as shit when I do it. But it just triggers in your mind going, if I don't do it, what happens to her?
Yeah. Remind yourself it's for the right reason.
Yeah, and so that's why I say to all of these ones that are self-representing, I mean, I think there's what, 5 that I'm giving a hand that are self-representing at the moment, and they've all noticed the same thing. Okay, like one particular mother in Wanganui, 9 years with a lawyer, getting nowhere. 6 months doing it herself, 3 changes straight away.
Yeah. So the lawyers, there's proof in the pudding that lawyers. There's proof in the pudding that lawyers aren't really doing anything to help matters other than helping themselves.
Well, the funny thing with her case was she went to the, I think it was the family court to go and file some papers, and she actually saw her old lawyer.
Oh,
and the lawyer turned and said, "Oh, how's your case getting on?" She goes, "A lot better than you did. I've managed to get the guardianship discharged. I've fully got him back home again, and there was something else I can't remember the third one. But there's 3 things she's achieved in 6 months with a little bit of help that she couldn't get over 9 years."
With a qualified lawyer helping her.
With a qualified lawyer, because the qualified lawyer wouldn't make the applications.
Let's see, so 9 years, 9 times 12 is what? 108? So it's $108,000 that lawyer's made over 9 years.
Oh, yeah. But the interesting thing about it was, she kept on saying to me, "But I'm not getting anywhere." I said, "Why don't you seem to understand the fact that you've discharged the guardianship? Okay, you've managed to get your son out of a 101 and onto a support order. It's not the perfect answer, but it's still a win."
Yeah.
And she goes, "Yeah." And I can't remember what the third thing was, but I said to her, "Tell me when your lawyer ever achieved that." And she goes, "Well, she didn't." And I said, "You need to understand that, as I've had to come to understand, it's a slow process. Any win you can get is a win."
Yeah. The cogs turn slowly, but they do turn.
Oh, yeah. I mean, but in reality, in the High Court, like I said, the High Court, in there, we were literally told 2 years for an appeal, and we did ours for the first one in 60 days. The judicial review was a 70-day period. The 70 days hasn't even been, and we settled out at court and she's home.
For good. No more orders.
Good, yeah.
No more nothing.
Yeah. And you know what the best part about it was? No gag order.
Yeah. So we can have this conversation.
There's no gag order. It wasn't until after we had agreed and I realised, hey, there's no gag order. There's no gag order, you know? But it's just there, they want to have involvement anyway. Like they said, under 83(1)B, we'd want to be able to have that. Why would we want that? We're wanting it discharged. We're not wanting you to stay in their life forever.
Yeah, they're just trying to keep their talons in so they can still keep themselves justified. It's not right.
I mean, it's just one of those things. You've got to look at each individual circumstance that you're dealing with, and you've got to work your way. Like people say to me, "But can't you do it this way?" Well, your circumstances aren't the same as this person's, so it's not able to do it their way. Okay, you can, like, since just put a picture up of that, I've had, like, I think another 4 or 5 contact.
Yeah, thanks.
And how do I do this? And it's like, well, I need to know what you're trying to do and what the circumstances are of the actual reporter concerned, not what they say they're worried about, but what got reported, to be able to give you suggestions. They go, "Don't you give advice?" No, I never give advice, because I give you suggestions. Because at the end of the day, this is a suggestion. If you choose to take it, that's up to you.
Yeah, of course. Otherwise, we could get done for being legal, giving legal advice when we're not lawyers. Don't want to do that.
No. So, yeah, I mean, those are the important things for them to be able to realise, because kids get uplifted and the parents go into a frenzy.
Yep.
Not knowing what to do.
Emotions.
Yeah, and so by the time they come down out of that panic mode, the time frame for filing a notice of intention to appear is gone, and the notice of response is gone, and the lawyer that you were depending on didn't tell you shit that you needed to do it.
I guess the other way to look at it is, how do people start taking a bullet for this person, or I give my life for my child? Well, if you give your life for your child, battle the system, because at the end of the day, your child would rather you battle the system, get out the other end, have them come home and, work through. Because yes, you got the legal battle, but of course after you're going to have the, every day as it is, working through every day with my daughter, working through
20 years time, Bubs is going to know that you guys fucking stuck it in there and fought for it, come what may. You know, whereas it's the other way. It's, oh, you just let the system take me.
Exactly. So it's easy to say, I'll give my life for my child, but if you battle the system and you get your child back, or even with, if it's a relation's child, and you get them back within the whānau, that child's going to see and go, yeah, well, you may have gone and done this, but they fought for me and they made me change my life. They helped me become a better person, beat the system.
What's this?
You know, the generational abuse.
But what she's talking about, I can honestly say that I went through that from 14 to 16. I myself had an abusive childhood. I went from my mum's place getting hidings every day to my dad's place thinking, okay, at 14, thinking, okay, it'll be better down there, I won't get a hiding. And then I discovered, oh crap, it's worse.
Yeah.
And then all of a sudden I had a social worker on the doorstep who was taking me away. The one thing that went through my mind for the 2 years, I was only in care for 2 years, but the one thing that went through my mind was, I'm sitting here in a family home, mum and dad have the option to try and get me, why aren't they? And then, I stayed in that family home for a while, and then I got asked this question by the social worker, because I was cunning. At 16, you could get a leaving certificate.
Sure.
And the family home I was put in, the people just happened to have the same surname. So I got my leaving certificate and I put it under my camp paper. I said, can you put your 2 signatures here? I've got to go on camp and there's the permission underneath. So I waited till she was doing her bills like she did every week and she just signed the paper.
Just tricked her into getting the order going.
I got the 3 weeks certificate, and then the social worker asked me what I wanted to do. And I said, well, when you weigh it up, and this was it came out really bad when I said it. When you weigh it up, I've got to work out. I got hidings from my mum. I got worse hidings from my dad. Yeah? And I got even worse hidings in your family home. So I'm better off to go back to mum's because that's where it least hurt.
Yeah, of course. Weigh out the...
And she was like, why would you want to go back to somewhere where you're going to get hurt? Why did you put me somewhere where I got hurt?
Yeah, exactly.
And so for me, this journey was about, I know what they do in this system, and I can't let it carry on for my granddaughter.
Stopping
because
the
I
cycle.
know what she's going to end up going through. Well, when the first lot of the smacking occurred, I told Jess 3 weeks before, your daughter's been hit. And then we found out about the report of concern.
Oh, this is when Bubs is with the caregiver.
Yeah.
Yeah.
And so when it happened, like because we were seeing her through the contact and then what she was doing, I recognised it from what I had been through, and I just said to her, look, I don't want to upset you, but your daughter's been hit. I could see what's happening.
Yeah, you can see.
And then it was only like 3 weeks later we got the thing saying that she had been hit 6 times. Sorry, wow. They said once.
What amazes me is they didn't do anything about it after getting those reports.
Yes, but what really peeved me off was Judge Black decided in our June hearing last year that he would comment about it in his judgment, knowing that it meant that you don't have the ability to then chase it through the court.
Right.
So the only reason, and he literally put, I must mention about the hitting, on the basis that you can't do anything about it in regards to that. But with my latest thing that the one I was telling you about where I went to court for, right, I've discovered there's my new way of charging.
Which is?
Well, you can't chase something on the same cause to action, right? So when you deal with OT, this is something people won't know. In a high court, you've got to put down your cause to action, okay, and the background for it, okay, and then you've got to put down, you know what the statement claim is,
relief sort.
So most important is your cause to action. What is the cause to why this action happened? And then you've got to have your background to that cause to action. So if you've got a cause to action of care and protection, because OT can only go care and protection, right? So if you want to pursue it in a different manner, you would change something like that to negligence.
Sure.
Because now you don't have the same cause to action, you have the ability to pursue now.
Yeah.
And so a lot of people, what they look at is, I want to take this to court, but and they say it's an abusive process. The reason it's an abusive process is you've used the same course to action.
Whereas they need to look at somewhere like the Crimes Act and look at the other things. Is that right?
So yeah, you then got to learn to plead the case properly, put your case references in and stuff. Like the latest judicial review that we did, they said it was an abusive process, that the paperwork was an abusive process. I changed it, like and then all of a sudden the abusive process was gone. The justice that was going to be hearing it, even though Crown were turning around and saying, well, it's not got the particularization there. His answer was, well, I can see it.
Yeah.
He goes, the self-litigant, it's not there to the detail that a lawyer would do it. Fair enough, but it is there. And so it took a while to think. And this is the funny part I found about it. They put the same lawyer on that had done the appeal, but the minute the amended statement of claim came in, all of a sudden it was a new lawyer dealing with it.
Right.
Yeah, and he came back and pretty much admitted everything, and on the basis of the statement of defence, would not have succeeded.
Yeah. So, the reason they swapped lawyers?
Because of the fact that I had learnt from the judgments and then realised that I don't have the case laws in, I don't have the referencing, I don't have the citing. Once I did all of that, all of a sudden everything changed.
Well,
there was new lawyer.
It sounds like the
lawyer deal with it.
So the previous lawyer really didn't have the training, and they had put a supervisor in there or someone with more training to deal with it.
Lawyer when we first did the appeal in September last year. Yeah. So they obviously thought, well, you're only going to plead it the same way you did the appeal. And then they said they wanted to strike out. I was given the opportunity to do the amended statement of claim, redid it after reading all the judgments. I mean, like, I spent, oh God, how many judgments I read through. And so once I realised that, footnoted everything like that, then, I mean, like, there's 5 cases where I've done the paperwork, and it seems like these justices are trying to find out who's helping them.
Yeah. It's the common denominator, isn't it? Now, clearly you're getting help, but from who? I loved one of the people your help's response when they says, well, Your Honour, you'd have to do an Official Information Act to find out that information. Yeah. I thought that was brilliant.
Yeah, so it's quite funny, but I think the important thing for parents out there that are trying to get their tamariki back is, if you're trying through a legal aid lawyer, unless you've got one that's actually willing to do the work for the legal aid costs, your journey will go on forever.
Yeah, snowball's chance and help.
It's just useless, no point.
Yeah. And you've got to be wary of the legal aid part of it too, because once they reach 12,000 a year, they won't do any more work because they're not going to get paid for it.
Yeah, so they'll drag it out to the next year so they get paid. Yeah, keep the money rolling.
Yeah, so those are like I said, those are the important things. I mean, like, you can only go Section 39. They have Section 40 and Section 42 warrants. However, those 2 particular warrants are only available under 78. And those 2, the important thing to note about any warrant, I suppose, is this: just because the judge issued it does not mean the person holding it has to execute it.
Yeah, they have to see the grounds to action it.
Those are 2 distinctly different decisions. The fact that the judge issued it, the judge has issued it on the paperwork. Do you see that child needing care and protection? If you don't, you don't have to execute it. But New Zealand Police's mind is, I got an order from a judge, I have to do it. Okay, so my message to New Zealand Police would be, grow a set of balls and stand up for the child.
And learn that you have discretion to do things.
Exactly, yeah, you've got the discretion to do it. The problem is, you don't use your discretion to do it in the correct manner. And when it comes to a child, that's when it's most important. You got to start to realise, New Zealand Police have got to start to realise this. When an uplift order is given, are you sentencing that child to a death sentence because a lot of them die in care. At the end of the day, I don't know how, like I said to someone else on a post the other day, lawyers, and this applies to these police that uplift them too, and I get people will say they're only doing their job. Well, their job entails using their discretion on that particular order that they've been given, the warrant that they've been given, and it doesn't say they have to execute it. It says they must search for the child, and if they believe the child's at risk, take the child to a place where the child won't be at risk. However, if you know that the child in front of you is not at risk, leave them alone.
I.e. sound asleep in bed.
Well, realistically, our kids, our tamariki that are going through the system, I would say myself, have it worse off than people that are sentenced to prison. Because at least in that fact, we can, if you get sentenced to prison, you can look after yourself.
You can defend yourself in prison. Children are defenseless.
Someone else.
You can speak out.
And the unfortunate part is if your child is anywhere between 0 and maybe 5 years old and doesn't have the ability to speak out or is too scared to, especially if like a puppy, with Bubba being 2.5, 3 at the time, she doesn't. A child that young doesn't have the ability to go, I need help.
Yeah, of course.
And even if they do, the system doesn't fucking listen to them. There's no point in having Section 11 of the OT Act saying child's views and Section 6 of the Care of Children Act saying child's views if you don't fucking listen to them. Because if you don't listen to them, you're sentencing that child to being hurt in a lot of cases. And in some cases, like Malachi's case, you're sentencing that child to death.
Yeah.
You know, that poor little child shouldn't have had to go through any of that.
No
tamariki out there should have to go through anything of what they're going through. If my view on it is this: if you believe that that child is in need of care and protection, get the whānau together and get them working together to keep the child with family.
That is the way.
That's the way it should have been. I remember back to my dad telling me how the Māori wardens work. That is the way it should be working. Going door to door each day and just checking on the whānau to make sure everything's going all right, okay, and making sure the kids are getting up to school and fed and everything. Why does the Crown feel that they have the ability to go and come in and go, I'm the better parent? But hello, when the child dies, you're not the better parent and you don't want anything to do with it.
No, they just hand your child back to you.
Here's the disgusting part about that, Mark.
Yep.
If your child is under the care of OT and you don't get to have contact or anything with your child, and your child passes away, do you know what happens? Automatically the orders are gone and you can have your child back, but your child is dead and you now got to pay to bury them.
Oh, of course. We've fucked it up, we've killed it, but at the end of the day, you know, that's disgusting.
It was a case that was televised over in Masterton. The parents were on the news and that. Their child passed away. Okay, the minute that the caregiver went to go and pick him up from the funeral home, was told you can't. The parents have the custody back now. The custody order's now gone because the child died.
Yeah,
but guess what? OT don't want to foot the bill to pay for the funeral.
That is so wrong in so many ways.
Yep, it is, and they just don't accept any blame for it. And you know, realistically, the way I see that kind of case is that social worker acted in bad faith, and you've got the proof of it.
Yeah. Dead child sort of sums that one up.
So many kids go through it. Yeah.
Oh well, guys, thank you very much. I'm gonna no doubt edit this up and put in all the relevant parts, and it's going to take me days to go through what you've just mentioned and pull them in it. But that's fine.
Well, we're happy we could oblige.
Cheers for that, guys.
I meant what I said on my post though. Like, I don't know, like, that's why I didn't share my post out publicly, was what I posted on my personal Facebook, because I didn't know, I know normally you don't really care, but unless I have permission from you and Fifi, I won't post it out everywhere.
I'll just say, you know, I don't mind. You know,
that's why
my life's been on YouTube for 10 years, girl. So,
yeah.
But I appreciate
it. It is important for people to know their rights and implement them. Yeah, you can know all of your rights as much as you like, but if you don't implement them, what is the use of knowing them?
Yeah, yeah.
Make sure we're good and support
It's the old story,
I can honestly say that at 51, I've learnt more in the last 2.5 years than I learnt at school.
Yeah. I'm the same way, mate. I've always been, in the 10 years that I've been studying law and stuff, just because of my speeding ticket I got, I thought to myself, why the hell wasn't I taught this at school? And it's obvious, because they like to keep the public ignorant of what they can and can't do. And, you know, the other thing being is that the court only exists, it's a two-dimensional thing. It's just a piece of paper, unless man or woman acts on those words, giving it life and effect. So, you know, a good thing is to try and detach yourself emotionally from what you're trying to do in court. Like you've said before to other people, read the evidence, but don't read it like it's something personal about you. Take that one step back.
You know, that's the one thing that I do regret doing when it came to one particular person, because you know how I was telling you about the one where I had no idea it actually was about another whānau. But that's what I've always said to people. Now, when you're reading it, to take the emotion away from it, read it like you look reading about someone else's whānau. But then to find out it was about someone else's whānau, I was like, oh no, you know, I just made you go through something even more. And she said to me, this is what she said to me, no you didn't, because what she goes, I've had my file for a number of years, but I was too scared to read it. And I was like, okay. She goes, it wasn't until you said to me, read it like it's someone else. I was like, yeah. She goes, that's when I had the ability to read it. Just, you weren't to know it was going to be about someone else's family. And I was like, yeah. I said, well, no. I said, but that's just the only way I could think of that you're not going to look at it emotionally. And she said, no, but what you've helped me to do was get through it all. And she goes, reading my file, I had no idea any of that was in there. And I was like, well, yeah. Yeah, I mean, it's pretty sick when you find out that things have happened, that your two kids, one kid from another family, your kid's supposed to have had something happen, but they've never met one another.
Yeah, how'd that work?
Yeah.
The thing is, even if you, like, Dad says that, and he said it to me multiple times, I'm like, to me it's easier said than done. When you're going through it, it's easier said than done. But the other way you can look is, if you can't do it like that, and it's still going to get you upset, then have your moment, but make that, have you the determination to drive and get home.
Yeah, turn that frown upside down and turn it into energy. Yeah.
I think
otherwise you're just not going to get anywhere.
What I find when I read stuff is, and it may not apply to everyone else, but anything that I read, even if it's something else to someone else's case, if it makes me mad, write it down. There's one of your things. Like, I was talking to another guy the other day who got their judgment from that. He was her support person, and they got their judgment. And he goes, well, we're looking at judicial reviewing, but I don't know how or what points are going to judicial review. He goes, but this part makes me mad. And I said to him, read it out. So he read it out, and I said, right, congratulations, you just found your first point for your first one for your judicial review. He goes, how? On the grounds of irrationality and unreasonableness and judicial impropriety.
Beautiful.
And he goes, okay. And I said, so when you're reading something like a judgment, if you see something that pisses you off, more than likely you've got a ground.
Yeah,
you just got to figure out what ground is. Yeah. And like,
it doesn't piss you off, but gets you emotionally upset with what happened with Bubba, you know, use that and have your moment, like I said, and just, you know, use it to get.
Yeah.
Brilliant.
Because you're always going to find that, like when you read something and it makes you mad, you've got something there. Because if it can trigger you on something, then work out why it's triggering and what the ground is. Pursue it.
Yeah. Excellent points. All right, guys. I'll leave it to you. Okay. You've got a pub to get up to in the morning. Brilliant stuff.
Yeah, that's what I was going to say. I got to go and get some rest, because,
that happens. Thank God mine have all grown up. That's all I can say.
I'm really going through that stage. I want to be an adult. I'm like, well, when you become an adult, fella, you're going to go, oh, what's wrong with you?
Oh, here, do you want to know here's the funny part. She went for her first visit at school.
Right.
here's the funny part. The teacher recognised Mum from when she taught her 20 years ago.
Oh, wow. That's pretty cool. The teachers must love the fact that they get to see generations come through.
Yeah.
Oh, yeah, well, I mean, like, it's weird because my granddaughter is now going to be going to the school that I went to in primary.
Wow.
Yeah.
That's impressive. All right, guys.
So, yeah. Okay,
I shall leave you to it. Have an awesome evening. Thank you very much for sharing your story. And, yeah, I'll send it to you to have a look at before I post it. And just give it a nod.
Okay.
All right, guys.
Have a good one.
Yeah.
Bye.
Have a good one.